Okay. Thank you all for being so timely and being here to with us for our session today. We've had a really great response for this session, and so we're so grateful for you all being here. In the interest of time, we're going to get going. I want to, first of all, welcome you all to this session discussing the revised NAPSA standards, which are going to be released here in the coming weeks. This is the 2024 version of the NAPSA standards. My name is Wendy Venverlo. I get the pleasure and honor of being the Executive Director of NAPSA. I just began this employment in early August, and I am just thrilled to be with you today. For those of you that were with us in New Orleans at our conference last month, this was one of the sessions that would have taken place but had to be canceled because of the hurricane that was coming. And so we are so thrilled to be able to bring this to you today so that you can have this valuable content. At this time, I'm going to turn the presentation over to my colleague, Spurgeon Kennedy.
Hello, everyone. For those of you who don't know me, my name is Spurgeon Kennedy. I'm Vice President of the Crime and Justice Institute. I'm also past president of NAPSA. Joining me are my fellow members of NAPSA Standards Committee, Janice Dean, Deputy Court Administrator for the 5th Judicial District, Pennsylvania, Allegheny County. Janice is also NAPSA's Northeast Regional Director. And Elizabeth Simone, Director of Maine Pretrial Services. So what we want to do today is introduce you to the 2024 NAPSA standards. They should be released hopefully within the next 60 days or so. We're fingers crossed on that. But we want to give you an idea of what is different, what's new, and also what the plan is moving forward. Before I start, I also want to give a shout out to our other two members of the Standards Committee who weren't able to join us today, Barb Henke, who is Director of Public Services in Oakland County, Michigan, and Brian Britton, who is Court Manager in Volusia County, Florida, and also NAPSA's Vice President. NAPSA has promulgated standards. You can go back to the other one.
All right.
James, sorry. NAPSA's promulgated standards since 1978. We consider them the contributions, the unique contribution that NAPSA makes to the pretrial field, along with our annual conference, accreditation of pretrial agencies, and certification of pretrial professionals. However, traditionally, the updates of these standards have been a little haphazard. You can tell by the years. 1978, the first standards came out. They weren't revised again until 1985, and again until 2004, and again until 2020. Certainly, when you don't have a regular schedule of updating standards, you run the risk of the standards being left behind, especially when it comes to what's new in research, what has changed with statute, what has changed in case law, and what is now considered legal and evidence-based practice. That certainly is something that we think happened between 2004 and 2020. The standards that were set in 2004 simply didn't meet the world we saw in 2020. So to make sure that the standards were reviewed more regularly and that additions were put out more frequently, NAPSA in 2008 developed a standing standards committee. We review the standards on a 2 to 4 year review cycle. If we believe that enough has changed to put out or to warrant putting out new standards, we do that. And that's why you see the 2024 standards being released. Go to the next slide. One of the things that we changed in 2020 was the direction of the standards, or what the standards emphasized. In the past, we were really concerned mostly with pretrial services agencies, and honestly, that will always be NAPSA's primary focus. But we also realized that a good, effective pretrial agency working in a poor pretrial system really wasn't much good. So we changed the mandate not just to describe what a good agency looks like, but to describe the components of an effective and legal and evidence-based pretrial system. What does a good system of bail setting, bail decision-making, supervision, the whole 9 yards, what should that look like? That really acknowledges for us that for most America's courts, real reform is going to be systemic reform. You can improve your agency, great and wonderful, but as long as your system doesn't change, you're not going to see the kinds of changes that you want. So that's why you now see the system focus. The new part that we introduced in 2020, which we'll talk about, are the effective elements of a pretrial justice system. There were a lot of standards that were already there in 1985 and 2004, but really weren't put in place the way that we thought they should be to really talk about what a good system looks like. Janice, I'll turn it over to you.
Thanks, Kenny. Welcome, everyone. So some of what Kenny had talked about between in the 2020 revision, a lot of, like he said, a lot of the stuff was there. We just kind of reorganized it into something that made sense to people, so you could pick up the standards and really just look at what was system, what was agency based. So what we really kept from the 2020 to this revision of the standards was describing the components of an effective legal and evidence-based system. We updated the standards because there was lots of developing knowledge about best and promising practices, legal definitions, changes in the field, lots of case law. So we updated all that. That's still there. We set a higher bar on what's realistic for justice systems to accomplish. So while a lot of times people think of standards as being aspirational, these are also very realistic, and everyone can do them. You could do parts of them. Most places aren't going to be able to just take and do everything at one time, but these are very realistic. They're aspirational, but they're something that you can work towards. And there are places that are doing all of these things, maybe not all of them together, but lots of good examples. We also wanted to keep in there strengthening NAPSA's support of independent pretrial agencies, and validated outcome assessments and the abolition of financial conditions of bail. We are very clear on that. We do not think money bail, whether it's deposit bail, straight bail, cash bail, surety, whatever, that there should be a prohibition on all financial conditions of bail. New in 2024, so we updated literature detailing the basis for best and promising practices. So there's things in there with examples, inclusion in changes in bail laws. So, at the time, the state of Illinois hadn't changed their bail laws. So case law related to that. There's some new case law coming out of New Jersey, some new for the 2024 standards. And, it continues to evolve the legal definition and requirements of a pretrial justice system. So we changed the language from defendant-based to value-neutral language. So instead of using defendant, we're using individual person, and we are changing the risk assessment to a pretrial outcome assessment. We have lots of examples in there on risk. In terms of risk, you're talking about, small risk for reoffense and failure to appear, and even smaller risk for those individuals that are going to perpetrate violent crime. So we're changing this to outcome assessment instead of a risk assessment. And we have new standards on alternatives to in-person court appearances, behavioral health and social services, work and caseload ratios, and telephone and virtual reporting, excuse me. Many of these new standards on some of the new things that we're going to talk about really came from advances that happened during COVID. So jurisdictions did a lot of things that they didn't think they would ever be able to do. And then COVID hit and we didn't have any choice. So, you know, we'll talk a lot about in the standards on, especially with behavioral health and social services, about not making that a condition of bail, but really for programs to offer and have information available to clients so that they can avail of those services. And now I'm going to turn it over to Elizabeth. Thank you.
Thank you, Janice. So in this slide, we're looking at the guiding principles for pretrial decision-making. These are found in part 1 of the standards. I think you'll see that just as in the 2020 revisions, it's laid out very nicely and easy to follow. I'm just going to tick off some of these for you. Goals of bail, which we refer to as the 3 M's: maximizing release, maximizing court appearance, maximizing public safety. Those are found in standard 1.1. Bail conditions based on individual risk factors, meaning don't do charge-based decision-making. That's found in 1.2. There's a presumption of non-financial release. And I think everybody understands that this really is starting to be a universal or a norm in American justice. Most jurisdictions do have some acknowledgement that there is a presumption for non-financial release. The next one is exciting for NAPSA: prohibition on financial conditions. That is clearly spelled out in standard 1.5. And I think it's important to note that NAPSA is the only entity at this time in the American criminal legal system that takes that strong of a position against financial conditions. The next one, detention as an option for public safety, is in 1.6. And essentially, jurisdictions can have and should have a detention mechanism for a carefully circumscribed group of defendants that pose unmanageable risks for non-appearance or public safety. And then finally, and very importantly, victim safety should be recognized. That shows up in standard 1.9, and it is to assure the rights of victims being recognized at the pretrial stage. And they include, but aren't limited to, simple things, but very important things like notification of pretrial hearings, bail decisions, any release that's related to the victim's safety, things like that. Next slide. So this is 1.5. We alluded to that in the last slide. This is really, I think, a critical standpoint for NAPSA and for the national standards for our field. Pretrial agencies, in addition to financial conditions of bail being prohibited, pretrial service agencies should not recommend financial conditions of bail. I just want to let that soak in. It's really important. Research has shown us that that is not anything that affects or enhances appearance or public safety. There has been litigation across the country that has addressed this as an issue. And interestingly, this is the original position of NAPSA in the first standards body. When we were looking at the 2018 work crew to come up with the revisions for these standards, one of the things we talked about is taking a bold position and being the leaders in the country to do that. For a defendant, whether it's surety, whether it's money, cash money, or otherwise, money is money is money. If you're detained, it makes no difference. So this is a very important standard for us. Thank you.
This is the part that we had talked about being added back in 2020, the essential elements of an effective pretrial justice system. Again, a lot of these standards were in the 1985 and the 2004 editions. We just didn't think that they were where they should be. This really is our vision of what a high-functioning, very effective pretrial justice system should look like and the elements that it should have. Number one, law enforcement options in lieu of arrest. Police should be able to do something with individuals besides arresting them and introducing them into the criminal justice system. Bail statutes with a presumption of OR and a progression to supervision and detention. You start with the least restrictive option in bail. You only move forward when you believe that the person's individual risk level warrants that progression. You have prosecutors that screen cases pre-initial appearance or sometime after the pre-initial appearance. If a case is going to be disposed, if the charges are going to be dropped down, if options like diversion are going to be offered, they should be offered as close to the front end of the system as possible. You need to have engaged and active defense representation at initial bail. You need to have someone as an advocate for that individual, someone who's knowledgeable about the individual, knowledgeable about the case, and can speak very well on the issue of bail. You need to make sure that the first bail decision isn't the only bail decision. And that happens in a lot of jurisdictions, particularly when that first bail decision results in detention. You need to have a system in place where bail is reviewed sequentially, a regular review of bail, especially bail that detains individuals. You need to have an established pretrial services agency. We'll talk about that with part 4. You need to have a validated pretrial outcome assessment that lets you gauge the likelihood of an individual making a court appearance and remaining arrest-free pretrial. Your supervision needs to be tied to individual risk levels and risk factors. In other words, you don't simply want to put a person on a particular level of supervision because they fit a box on a risk matrix or because they're charged with a particular kind of offense. You need to find individual risk factors and you need to match those up with conditions that make sense. This is a lesson learned from COVID. You should have alternatives to in-person court appearance, virtual court dates. Also, determine whether or not there are court dates that individuals don't have to go to. Do I have to go to a status hearing if I'm a defendant? Sometimes the answer to that is no. In a lot of jurisdictions, they have identified those court hearings that are mandatory for a person to come to, but also those hearings where attendance isn't required. And finally, adopting pretrial system performance metrics so that you know that your system is meeting its goals and objectives. Let's talk about Standard 2.7. NAPSA has always promoted the establishment of pretrial services agencies. We believe that pretrial agencies are a vital component to effective pretrial systems. In fact, you will not find a well-functioning pretrial system without a pretrial agency. So 2.7 continues that advocacy. Standard 4.1a, what the purposes of a pretrial agency are. And there are 2. You want to help judicial officers make better decisions that promote court appearance and public safety. You want to provide the court when needed with practical risk-based supervision and support options for those persons that need that level of oversight. Something else that we put into this standard is in years past, I shouldn't say we didn't care because we certainly do, but we weren't that particular about where pretrial agencies were located. You know, you can put it anywhere. You can put it under a probation department. You can put it under a jail. You can put it under the courts. You can put it under social services, as long as you established an agency that was okay. The 2020 standards went away from that, and we became a lot more particular about where we think agencies operate. NAPSA's preference is for standalone, dedicated pretrial services agencies, preferably those under the executive branch. We do understand that in some jurisdictions, you're going to have pretrial agencies that are part of larger organizations. But when you have that, the pretrial agency should have a clear director It should be able to determine its own staffing, its own budgeting, and its staff should only be working on pretrial related matters. You should not have your probation officer hat on from 9 to noon time and then your pretrial hat from 1 to 5. If you work pretrial, you have to be a pretrial agency. So that's different than standards in the past. I'll turn it over again.
Well, if we could take one quick pause, there's a question in the chat, which I think might be timely for right now. The question is, can you talk about using the term supervision versus the term monitoring?
Yeah, a lot of people use that interchangeably, and I'll give you my personal definition of both. Monitoring is simply the lowest level of oversight that you have, that I'm notifying you of upcoming court appearances. I'm letting you know that here's a person that you can contact if something comes up regarding court dates or anything else, any other emergencies that might happen. And I'm doing something if you either miss a court appearance or are rearrested again. To me, that's monitoring. Supervision involves active, routine conditions of supervision that have to be managed. Am I reporting to someone regularly? Am I involved in drug testing? Am I wearing a electronic bracelet? Those kinds of more labor-intensive activities are more along the lines to me of supervision than of monitoring. But Janice, you and Liz certainly might have different opinions on that.
Yeah, so I was just going to say the way we look at monitoring would be the people that that are just being monitored for new arrests or failure to appear. We still send them a court date notification, but they're not coming in. They're not having to phone in. They don't have to report in. There are, sometimes the monitoring aspect of it will have a stay away order or something like that. And they have that information. We would know that they violated that if they get a new arrest. If someone calls, someone calls the district attorney's office and says they have a stay away order, they're still coming. But those are monitoring where we're not actively bringing someone in, or they're not actively phoning us, as opposed to supervision where they're either coming in, someone's seeing them, or they're phoning in, or on electronic monitoring. Correct.
I agree with what Spurgeon and Janice have articulated. I would only add that for the field, it is important to base these decisions on what the pretrial outcome assessment indicates. That helps with what we would call contact standards in the field.
Wendy, was there any follow-up to that, or was that
that was the only one? Thank you.
Okay, perfect. Me advance slides, I think. Elizabeth.
Pretrial release and detention decisions. This is what makes up part 3 of the standards. And in looking at this, we're talking about the criteria for release prior to the initial appearance hearing. We find that it really elucidated in 3.1, if you're looking at the standards, what the some jurisdictions have different modes of doing this. There could be a delegated release authority. There could be a contractor for the courts. In Maine, we have a bail commissioner, but there is a mechanism and there is criteria attendant to what is an appropriate release prior to initial appearance before a judicial officer. The next one, preference at initial appearance for release on own recognizance or personal recognizance with conditions ordered only when the risk levels or factors permit or indicate. This one is in 3.2, and it really is about informed decision making. There is a presumption that you're going to be released, and if and only if there is an indication that there needs to be a condition or combination of conditions, should those be ordered to try to mitigate risk of non-appearance or of threat to public safety. The next one, clearly defined criteria and a population that's eligible for pretrial detention. This comes under standard 3.4, and this is an important one. This has to do with detention decisions, obviously. And I'm just going to read to you from 3.4a. Jurisdictions should define and justify the criteria for legal pretrial detention, keeping in mind, and the famous quote, liberty is the norm and detention should be the carefully limited exception. Detention without bail should target a limited, carefully defined population and require the government to show by clear and convincing evidence that an individual fitting detention eligibility poses an unmanageable risk, either for dangerous or violent offense or for willful non-appearance. The last one, subsequent review. Kenny talked a little bit about this. Subsequent review is elucidated in 3.5, and it has to do with how we deal with and the process with release and detention decisions. It includes factors like how a judicial officer can modify a bail status, meaning detention, the rights of both prosecution and defense regarding detention and detention hearings, the court's response to noncompliance, how to manage a revocation with detention, how to contemplate temporary release if a defendant has an emergency situation and needs to get out. Next slide. So this one is a specific standard, 3.3, and 3.3a really talks about how all persons have a statutory presumption of release. And that's PR bail, OR bail, whatever your jurisdiction calls it, with a requirement that they attend court proceedings, not commit any new offenses. The presumption can be rebutted by evidence, as we've said before, of a substantial risk of failure to appear for court appearances or a risk to public safety that warrants a greater level of monitoring or supervision. So basically, these risks that cannot be mitigated unless there are conditions of supervision. So supervision would address them or mitigate the risk, and the conditions have to be least restrictive needed to address the identified risk. So the Federal Bail Reform Act of '66 created this presumption in favor of release. In 1984, the Federal Bail Reform Act was amended, and it then added the community safety piece. The presumption of non-financial release is now, as I said earlier, near universal in all bail statutes nationwide. And finally, conditions that will help for appearance or to protect public safety are really only appropriate if they are least restrictive. It has to be tied to what the risk is. As outlined in the Federal Bail Reform Act and other statutes, before conditions are set, the judicial officer has to find an individual's likelihood of that risk of either non-appearance or threat to be to need the specific factors, and any other types of conditions would be inappropriate. Thank you.
Who unmute, Janice?
Sorry, I was trying to mute myself and I actually did it. So pretrial service agencies' purpose to assist courts to make fair and informed bail decisions and to provide practical and individualized monitoring, supervision, and support. Right. So I think, and this is from 2020, support where we kind of honed in on a little bit in terms of offering clients supportive means, right, to show up for court and remain arrest-free. So things like we get lots of times people question, how do you make someone go to drug and alcohol at the pretrial stage, and you're doing a pretrial outcome assessment, which is just really looking at appearance and public safety, but you're not doing a, some of you guys may not do or don't plan to do any type of needs assessments. So when you're talking about support, you're talking about what you can offer people without making that a bail condition. So you can, give them information on drug and alcohol evaluations if they need it. Give them information on where to go for, housing supports, food support, things like that. Your pretrial agency, you want to make sure that you're screening, interview, criminal history verification for your outcome assessment, making a recommendation, supervision, and then measuring what you're doing. I know a lot of jurisdictions use the public safety assessment that does not require an interview. We have been very clear that you can use that, but if you're going to be supervising clients and you're going to be sending them court reminders, getting information from them on where they're living, a good phone number, an email address, things like that, that's only going to come from, we believe, from speaking with the defendant. If anyone's under the illusion that the police will gather that for you, that's probably not going to be very accurate or the case in most jurisdictions. So really, when we say interview, it could be a traditional interview for a outcome assessment, or it could be the fact that you have the information that is required for a assessment that doesn't require an interview, but talking to that person and getting that information is really vital if you're going to follow that up with supervision, which would be your best practice to make the recommendation, do the interview, make the recommendation, have supervision, and then measure what you're doing. New is workload and caseload ratios. And I think Kenny and Elizabeth both said within the next couple of weeks, we're hoping that these are out. We made the recommendation to the NAPSA board of directors and gave them an option for comments and any type of revisions that they would like. So we're currently going through that now. So hopefully we'll be done with that and we'll have a final product for everybody. Confidentiality and release of information requirements, which was again promulgated in the 2020 standards, which remain in this iteration. So 4.1 talks about your agencies, really as adopting what your core functions are to support your purposes, collect and verify individual background and criminal history information for all individuals eligible for pretrial release. So one of the things with when we say all individuals eligible for pretrial release, that's really by your statute. And in most jurisdictions, just about everybody, right? Maybe sans capital cases are eligible for pretrial release. So be very careful that your jurisdiction is not limiting who pretrial can make these recommendations on, do these interviews and make recommendations. We have a couple examples from the state of Pennsylvania that, at some point during their pretrial lifespan, someone got the bright idea that they should not offer an assessment and supervision recommendations from their pretrial program on gun cases, right? One case goes bad, then they don't do. And next thing you know, you have all these exclusions. You should be interviewing everybody, even the people that may not be eligible to get out, because if a charge changes, if something happens with any of the charges that would prohibit them from getting that, you have that available and you're ready to go if something happens. Again, you're doing assessing individuals' likelihood of future court appearance and crime-free behavior using factors shown by research to predict the likelihood of pretrial failure. So talking about, an outcome assessment on that. Using an individual's background, interview and investigation, criminal history, risk assessment results, and other information to formulate appropriate risk assessment results, recommend appropriate conditions of release and supervision, and then actually supervise and monitor the individuals released pretrial. there's any court-ordered imposed conditions, you would want to make sure that you're monitoring those. And then, however your jurisdiction has notification to the court, prosecution and defense of an individual's compliance or lack thereof compliance with the conditions, and recommending appropriate changes to status and conditions. So I think one of the things with that is just like not reviewing someone. So initially their bail gets denied and no one looks at them again. Pretrial supervision can become stale. So depending on the time to disposition in your jurisdiction, some people have really good time to disposition. Some people don't have as great time. And so you are finding people on pretrial supervision for a really long period of time. And during that time, things may change. Someone may have gotten their GED. They may have gotten an assessment and completed some type of, recommended treatment with that assessment. There could be a lot of things that happen. So all of that stuff should be reevaluated and looked at. And, we've done some here in our jurisdiction, we've done some looking at the time on supervision and really found that almost 90% of our pretrial failure happens in the first 49 days of supervision. So, having the ability to do that, we can take people back to court and reduce different things just because we know that most of the non-compliance is happening up front. And review the status of detained individuals. We talked about that a couple times. That's really important, that you don't just bail gets set, they're off of your radar because you're not supervising them, and then you don't think about them again until maybe never. And you really have to review those because things change, charges change. And if you don't have a good system that is taking kind of these bail modification requests or information from defense, bar, or someone else, then your pretrial program should be looking at those people. And Penny is up.
Talking about next steps, what are we doing between now and hopefully the end of November and getting the standards out? Well, the document has been reviewed by NAPSA's board of directors, and that's an important step because NAPSA has to certify these standards. The board of directors has to. We've gotten comments back. We will meet again as a standards committee and consolidate those comments, make those revisions. We hope to do that before October 25th, which is rapidly approaching. We want to have a period of public comment. We're scheduling that hopefully between October 26th, November 15th. That is to put the standards out there to the public, let you guys look at them and give us your feedback on it. The public comment will also include a survey, a very brief survey, asking you your opinion of the standards. Are they complete? Do they cover what we believe standards like this should cover? Are there some things that we can word differently or be more clear about? Those sorts of things. We will then take your feedback, and if we need to, with the board's permission, make changes as needed to the standards. And again, our projected time of release is somewhere around November 22nd. We're really shooting towards the end of November. So we really want to have the standards out before the holidays really hit. So we're looking at the last week of November, maybe the first week of December if we really get delayed. So that is where we are with next steps. And I believe we can open it up to questions. Is that the next slide, Janice?
Yes, and we actually
have a few. Yeah.
So go ahead, Wendy, if you want. I just pulled them up while I was listening to Kenny.
Yeah, I was going to start. There's been, if you've been following along, there's been some questions in the Q&A section of this meeting, and Kenny has been answering, or Mr. Kennedy has been answering those as we've been going. So the first one was, could we get a copy of this PowerPoint? The answer is yes, and I will do my very best to get that out to you. The makeup of this webinar is that I don't have the ability to attach it right now to you so that you can all have it here. But I will get that emailed and hopefully uploaded in another way. And so you should receive that. If you do not receive that in the next 24 hours or so, my email address is execdirector@napsa.org. So that's an abbreviated executive director at napsa.org. So you can reach out to me anytime. Then another individual had said, I think we just addressed this in the slide of when the standards would be published. So that's hopefully near the end of November. There was a question of whether pretrial services interviews must be before release, but would it also need to be before the initial appearance? I don't know if you wanted to expand upon that, anyone?
Yeah, so go ahead, I'm sorry.
No, go ahead.
No, I was just reading your, yeah, so the goal would be to have that available prior to initial appearance so that the court has additional information in which to make that bail decision, release decision, or detention decision on. A lot of jurisdictions struggle with this because they don't have staff to do that, prior, depending on how often your initial appearance happens, how long it is from someone's arrest to that initial appearance. So the goal to work towards would be, yes, to have that. There are jurisdictions that do it after that and then take that information either to that same branch of judges or a higher court to have that reviewed. And so that can happen too. It does, though, delay a person's getting out of jail. But it can be done that way, making an argument that, hey, this happened 3 days later, we could save 3 days by bringing all of this up front. So, if you can't do it up front in the beginning, work towards getting it up front and use that data of people that you get out like 3 days, 5 days later, however long that would be, to sort of talk about saving those jail days, because your beginning part of your jail intake and processing takes the longest and it's most expensive for the jail.
The next question that was answered in chat is, can you clarify what you mean by recommendation?
Yeah, my answer to that was, and the standards really define it as what the agency suggests to court as the most appropriate level of supervision and the most appropriate conditions of supervision. So that is the agency letting the court know, as a supervision agency, and also as someone that has screened this individual, that this is what we believe is appropriate when it comes to bail.
Right, and a lot of that's going to change depending on what your agency has sort of in the toolkit to offer for supervision.
Yeah.
Great. Another one that looks like Elizabeth just answered. This is the question. How do you recommend opening a dialogue with judges about these standards? Our agency has many outcome assessments that recommend release under our pretrial agency supervision, and the court decides to detain time and time again.
So I can just say what I put in the chat, and I'm interested in what Mr. Kennedy and Ms. Dean think as well. For us, it's been very helpful to just publish the standards and be very transparent. This is what our profession indicates are the best practice standards that are rooted in research and literature, litigation, court case and precedent, and then best practice in the field. I suggested that perhaps if your jurisdiction has bench bar meetings, that's a really nice forum in which you can share. And I also added just a little note that NAPSA has, as an organization for quite some time now, considered that anyone involved in release or detention decision-making is a pretrial professional or a pretrial practitioner. And therefore, these standards could and would apply.
Yeah, I agree. One other thing that I think is really helpful in kind of whether it's judicial officers, whether it's, attorneys, prosecution, defense, whatever, is data. So having data to show successful outcomes. We've finally got people to realize that assessments are assessments not on that individual, but on a group of individuals who, have similarly situated backgrounds and information. So when you start to show data that this group, right, does really well, and releasing that, you can even go so far as giving judges individually, right, what happens in decisions that they make. So a lot of times they make these decisions, they move on and they don't know. So giving them information that, hey, you release these people. We also give judges information on you detained these people. They were detained for 8 months. They took a plea and they were released with no further penalty, which to me sort of doesn't make any sense, because if you were so risky at the pretrial stage that you had to stay in, but then when you got convicted, you got released, it doesn't make intuitive sense. So I like absolutely sharing the standards with everybody. We do that, but I also like giving people back data to show them the success and failures of different groups of people.
Very good. Thank you. The next question, I think maybe we've answered, but we'll say it anyway. What exactly is meant by an outcome assessment?
Yeah, and changing some of the language in the 2020 standards, one of the phrases that we did change was going from risk assessment to outcome assessment. And we did it for 2 reasons. Number one, when you look at the data, as Janice mentioned, and the amount of risk in most pretrial populations, at least those that bother to track that metric, you're finding that there's not a whole lot. Most people are going to make court appearances. Most are going to remain arrest-free. I guess my favorite example is in the federal system, individuals that succeed 80% of the time or die, are described as high risk. If that's your high risk population, you don't have a lot of risk going on in your populations. Outcome assessment, which is predicting the likelihood of an event happening, seem to be a much more appropriate way of defining what the assessments are, but also defining what the agency is doing. We're letting the court know that this person belongs to a group that has a higher likelihood of success or lower likelihood of success. Not so much here's a risk level that might get into some biases, both with the agency and also with the decision maker.
Thank you. This is a question about recertification. It says, do you recommend that staff that need to recertify wait for the new standards to be published, or could they go ahead and recertify now?
I would think they could recertify now. There's going to be, the education committee is currently discussing some new questions and so revamping the test. So yeah, recertifying now is fine. Things, may change a little bit over the next, when the release of the standards and some revamping of the test questions. But yeah, I think that's fine to recertify now.
If you are certified now, you will be certified on the 2020 edition. We're not going to sneak the 24 on you, so you certainly do it now.
The next question was regarding a change in language, the more modern language you discussed. It says, at the beginning, you stated that the defendant should be addressed as an individual and an assessment as an outcome assessment. Is that right? And did you want to make any comments about that?
Yeah, only that I used the word defendant once, and I apologize for that. Again, we try to go with language that we felt, did not have the weight of bias that some words do. In some jurisdictions, persons pending trial is still called offenders. And when you think of someone as an offender, God knows what you can do with them when it comes to conditions and requirements. So again, the value neutral language that we tried to pick really is a way of reducing what we think is bias in the system that comes from the way that words are used or the way some words are used.
Thank you. Okay, another question. Are there time standards for a suggested amount of time to be on pretrial supervision?
So, I mean, I could tell you what I would like time standards to look like, but I think, so a lot of that is really, we did not address time standards on supervision. I mean, most jurisdictions, like I said before, some are really good. Their length of stay is low. Some people carve out some easy cases and those are really low, and your longer cases are going to be. So no, but that is a note that we could maybe take a look at in the next iteration. We're hoping not to wait 4 years. We're going to maybe try to do this in 2 years. Like, they're looking at me like, I can't believe you said that. But yeah, sometimes, but we definitely could take a look at that.
But to Janice's earlier point on one of the previous questions, data here would be really important. It's important to track how long someone is on supervised or monitored release, and to show those trends to your system partners so that they can be accountable also to how long someone is. Weirdly, whether it was pre-COVID, during COVID, or post-COVID in our jurisdiction, we always have an average of around 90 to 92 days. Again, we carve out some of the outliers, people that have more serious cases that are permitted release literally and sadly for sometimes well over a year or longer. But most people are in 3 months. If you do have conditions that have to do with behavioral health, a good rule of thumb is it does take human beings about 90 days to affect any type of change. This, I think, is precarious in pretrial because of the presumption of innocence, and we don't want to force people to make behavioral changes. But if it is a court-ordered condition, that is a pretty useful rule of thumb.
Yeah, I was also sort of thinking that maybe, so sometimes the time that someone's on pretrial supervision is really outside of pretrial's control, right? Because it has to do with, availability of attorneys, judges, continuances, different things like that. But maybe talking more about what pretrial can do if someone's on for 90 days and the case has been continued, for 6 more months. Like, could pretrial then, maybe some standards for pretrial, if they're doing well, they finished everything, no new arrests, they've shown up for court, their next appearance isn't for like 6 months. Maybe pretrial approaching the court to reduce that supervision to just, OR. So maybe, looking at it that way. And I mean, there's no reason why agencies couldn't do that sort of on their own, and recommending things like that to the court.
Especially if you had a generic condition report as directed.
Right.
Another somewhat related is, do the standards address caseload ratios? And if so, what is that?
Yeah, the standards, and this is a new standard for 24. We do recommend that pretrial agencies conduct or have someone conduct for them caseload and workload ratios so that they understand the number of staff needed to supervise at the levels. For example, you're going to need more case managers to supervise an electronic monitoring unit than a unit that simply has people come in once a week. The reason that we added that is that over the last 4 years, and even before 2020, there have been some pretty good workload ratio studies done in the pretrial field. The Commonwealth of Virginia did one statewide. There was one done in Harris County, Texas, another done in Maricopa County, Arizona, and I'm blanking out on another one that was done. I think it was New Orleans, but I'm not sure. So we now have a bit of body of research that tells us that for a typical pretrial agency, if you're looking at how much time is needed to perform functions, and if you're looking for a suggestion on how many staff are needed to have those functions done, we now have more to guide us than we did before. So that standard does make that recommendation. Do we actually have caseload ratios in the standards? No, we kind of stayed away from that. So you're not going to see a 1:50 ratio for supervision or anything like that. But there is the recommendation that those kinds of studies should be done if you have the resources for them.
Okay, there's a couple questions here somewhat related, talking about having a pretrial agency as a standalone agency versus one that is housed within a larger. So the first question is, what is the impact of staff that supervise both pretrial and probation? Does this impact the individual on supervision, or is it on staff thinking, staff mindset?
So I think both. And Kenny used the example, which is probably, like we laugh, like from 9 to 12, you see people that were convicted, and from 1 to 4, you see unconvicted people. Yeah, I think that the mindset, it's very hard to switch that between here's how I deal with you when you're on supervision, when you're convicted, and you have all these things you need to do, as opposed to unconvicted. So while there are plenty of places that pretrial lives in probation, which is, I would say we haven't done like an actual survey, but it's an idea. But a lot of places are living in probation, just they have the resources, and they have that sort of, people think that they have that supervision experience. So you can do that, and it can be done well in some places, but they're really, pretrial is its own thing in probation, where they have their own director, their own mission statement, because your mission statements are going to be different, your own budget, and really a way to look at your own data and keep all of your own information. In many states, the pretrial information is more protected in the collection than it is in the post adjudication. So just having those things separated too is important.
I would say this would be a good point to mention the NAPSA NIC publication for the essential elements, because they do talk about the important characteristics for pretrial services or pretrial agency, and locus of control is key. That mission statement is so important to guide what you are doing and the functions and operations, and not to be swept in or combined with others. I can speak just super briefly. Our organization is an independent private nonprofit. And so it is very difficult to have funding. It's very difficult to garner support or move state systems. But we have a great deal of good luck in terms of being able to make independent decisions or ascribe to standards that we believe in, things like that. It's not easy to be co-opted if you're independent.
Years ago, Caleb Foote, a criminologist, said this about bail. The pretrial decision determines everything else. It is easily the most important, or one of the most important decisions made between arrest and adjudication. And the agency that helps inform the court about it and helps manage it while a person's released really shouldn't do it part-time. I mean, we are not a part-time practice. We are full-time. We are that important. And your agency, where it's located, what authority it has, how it's staffed, really should show how important that jurisdiction views bail setting and pretrial.
Great, thank you. There are two questions that are somewhat related. I'm going to try to combine them. And they are related to recommendations made by pretrial agencies in the investigation. The one says, should pretrial agencies make recommendations for release or detention? And then the other talks kind of similarly about the detention. Should the pretrial agency ever advise the court that there are no mitigating release conditions that could allow someone to be safely released?
So I can,
Standards, oh, go ahead.
go ahead. Sorry.
No, yeah, the standards clearly say that pretrial agencies should not recommend detention. You can certainly identify those individuals that are eligible for detention by your statute, but that's not something you should recommend. On the other hand, and I think, Janice, you brought this up again with what the agency is capable or not capable of doing. If you really believe that this person presents risk factors that you as an agency are not able to address, then certainly you let the court know that. I don't know if he would say that there are no condition or combination of conditions. That's getting onto a whole new level, but certainly saying to a court, we don't have the capacity to supervise this individual or these types of individuals. Yeah, I think that's perfectly appropriate.
Yeah, I was just gonna say, we do make those recommendations. There's no set of conditions or combination conditions that can assure the defendant's appearance or safety to the community. And we do make that, that's literally straight from our, and that's about 3%. That's really our highest risk individual. So not a ton, but we do let the court know that.
Great. Next question, and just again, thank you to the participants who are offering up these great questions. This question says, would you please be able to tell us a little bit more about the new standards on telephone and virtual reporting?
Those were, as we said, lessons learned during COVID, that you could actually use technology to complete an in-person report. The person didn't have to travel to your office for half an hour, spend 10 minutes with you, and then travel back home to work for a half an hour. If you're able to do that, if you're able to have a person pick up a telephone, if you're able to do it by computer or by cell phone, then it really doesn't make a whole lot of sense to require in-person reporting. Again, if you're looking at the least restrictive way of putting a person on supervision, that sounded a lot less restrictive than requiring in-person reporting. Give you an example. If Barb Hankey were here, she would proudly tell you that in Oakland County, they've never required people to report in person. They've always had telephone reporting, and their rates of success are the same as most other pretrial agencies across the country. So again, the technology allows you to do it. There's really no advantage of in-person reporting compared to telephone or virtual reporting. So that's the recommendation now in the standards.
Yeah, I think over we've said a couple times, like the COVID lessons learned. I think our jurisdiction and many jurisdictions were less inclined. Like people wanted to see someone, right? Like face to face, we'd be able to tell if everything was good. And then COVID hit and everyone was doing things either, FaceTime, phone, different things. And we were seeing the same rates. And so as things started to slowly come back, a lot of jurisdictions approached their courts like this. We were able to talk to people a lot more, give them a lot more information. It was faster for them. They didn't have to leave work. They could take a 10-minute break if they were at work, and go and come back. And so it was really valuable for the agencies and for the clients. So yeah, if you're able to do that and things that you did, so we talk about some examples, but yeah, there's probably 100 other things going on out there that we didn't cite in here, but just start to think that way. Because I think a lot of people, they got out of COVID and they're like, okay, let's get rid of all that. Like COVID was bad. So whatever happened during COVID must have been bad. But I think a lot of stuff in terms of courts and technology that we didn't have before is really amazing, and we should keep it.
And finally, if you see no variation between your outcomes, if you still have the same amount of successful outcomes, people that make it to court, people that don't get rearrested, there's your proof right there.
Very good, thank you. Here's a question from Illinois. With the new changes in bail laws in Illinois, there is now an increase of cite and release or tickets that are issued rather than a person being taken to jail. And so the question here says, is there an outcome assessment available that could be completed post-arrest or post-first appearance to assist the court with potential supervision and release conditions?
I mean, I would, so my first inclination would be PSA, right? Because you don't need the person there to really ask them any questions. So I would think that, and I mean, I know for sure New Jersey has it automated, you know, in terms of getting that quickly. And I think if I'm not mistaken, it's still even done by some police departments and facilities prior to. So, I mean, that's something to look into. I mean, if I'm reading the question correctly, that would be something that you'd be able to do without having the person there.
Other jurisdictions don't use outcome assessments as much as they simply establish release criteria. So in Washington, D.C., I think they're still doing it this way. If you don't have a pending case, if you're not on any sort of court supervision, and if law enforcement is able to verify your address, they usually do that through the pretrial agency, then you can be released on citation. So it's not so much a risk assessment as it is criteria that are established for release eligibility.
Great. Another question. Do you see an issue with over-conditioning a pretrial client in your jurisdictions, and how would you address that with the judiciary?
So I'm going to sound like a broken record again, but when we have people that are sort of similarly situated and some get over-conditioned, it would depend on what judicial officer that you saw at that time. We really use data for that. Just showing that, you know, people that have less conditions that are similarly situated would have good outcomes. And sometimes the people, you know, with more conditions, right, are going to have a greater chance for failure. So their failure rate's a little bit higher. And it's not because they're any riskier. It's because they have too much stuff to do.
And I would say to pretrial agencies, don't be guilty of what you're accusing the courts of. If you don't want to have people over-conditioned, don't over-recommend. That's particularly true of sites that might use matrices or other kinds of schemes to help with recommendations. If I fall into a box that has me reporting, you know, once every couple of weeks to pretrial, and I'm really not an appearance issue, then don't make that recommendation. Again, the standards really are clear about this. If you cannot find a specific risk factor that you're trying to address, don't recommend a condition just because you think you have to. So if you want to help the court not set conditions that are, you know, not needed, don't recommend those conditions in the first place.
And if it continues to be an issue, think about the conversations that you can have with the practitioners who aid in the decision-making, meaning prosecutors who may consistently demand a certain condition that you know and from your data know is not important to you. You can start to have those kind of smaller micro conversations to try to move the needle a little bit.
Excuse me, sorry. Got a few more questions here. Are there, this is talking about a workload assessment. I think earlier there was a question about the appropriate number of cases a pretrial officer should manage for different levels. It says here, are there agencies or firms that can help do that sort of workload assessment?
You mean, am I going to say to this crowd that you need to call CJI to have something like that done?
No, but one of us can.
Yeah, I wouldn't abuse my my place here that way. Now, yeah, there are organizations. Certainly, Crime and Justice Institute could do it, but other uh, organizations as well. Um,
And I think, that might be something for us to follow up on in our roles in terms of looking at, is there a way to build a toolkit? Can we publish
mm,
something that helps people go through some basic tick points that they can look at?
Okay. Have there been any discussions on set pretrial contact standards being different from probation contact standards?
So I'll dive into that. I know in our state, probation has specific contact standards based on a level of risk that they assess using the LSIR. Um, their contact standards are not only to enhance public safety, but they are to maximize scarce resources. So they don't have enough officers. There's too many people on probation. They will limit the amount of contact that should happen. With pretrial services, as Janice and Kenny were saying earlier, it really is not about the physical face-to-face contact anymore. It's looking at what has proven to be productive through research. And the most productive thing that we can see when we do have contact with someone is reminding them of court. In terms of supportive services, it's the next most productive thing. Do you need help with anything? We could, offer a resource, that type of thing. So you want to have contact with people in a way that is helpful to them to get to court, but not necessarily to be really structured around what you think the outcome is. Now, that said, I would also add, if you have someone that poses a risk that's manageable but still high, you may want to have contact more often, and you may want to be wrapping with more supports and looking at any conditions that have to be monitored.
yeah, if you have a electronic monitoring condition, for example, you certainly want to build in regular reporting there. Elizabeth makes a good point, though. The introduction of court notification as a regular routine part of pretrial really has raised the question about whether or not you need to have as many people reporting, however way they report, that we have right now. I know that APPA has recently come out with standards of their own. You should consult those to see what probation contact recommendations are made. I would also let people know that the Prison Policy Initiative a couple of days ago put out a report called One Size Fits None, where it looked at how people are violating probation and parole. And most of it isn't new arrest or bad behavior, it's technical violations, including failure to keep regular contact. So again, I think we need to be more careful and a lot more precise about why we are having people report, no matter what level of supervision you're on.
Okay, next question. Do you feel that pretrial officers should have a gray area where they could apply sanctions or incentives to folks in lieu of just violating or a violation of release? If so, how would you promote that approach?
So I think that that's a conversation with your court and how they want those things handled. I know in many jurisdictions, decreasing requirements if someone is doing well is within pretrial's purview, but increasing or sanctions, whether that's increased supervision, increased going from like phone in to electronic monitoring or phone in to report in person, needs to be on the record in court. So that's a conversation you need to have with your judiciary on how that should be addressed. Sorry.
Yeah, the standards do say that agencies should have a system of graduated responses, not only to bad behavior, but also, conforming behavior, because most people are going to comply with what's put in front of them. Janice is right, though, that needs to be determined based on what your court is fine with. So the first infraction, you can sit them down with a warning. The second infraction, you can do something else. You should be able to define that point, though, where this number of infractions require court action. And that's where the conversation with court needs to come. But yeah, there should be a system of graduated responses short of full revocation.
Okay, we have 5 more questions we're going to take here, and then we'll wrap things up. So this one is talking about when a person on release gets a new offense while on release, and the question is saying, or I'm sorry, when they're on probation, I apologize, and they get a new case that then ends up on pretrial. Should those cases go with the same officer, either both go with the probation officer for monitoring? Should they both go with the pretrial officer for monitoring, or should they be with 2 separate folks?
So I can talk about what we do in most jurisdictions in Pennsylvania. We would, pretrial would take that case. And if there were conditions that needed to be addressed at the probation side, we either probation can talk to that judge and let them know that they're doing this on pretrial. But usually on those cases, pretrial picks that up until that case is adjudicated or dismissed or whatever happens with that case. So that pretrial period's done, and then it can move forward.
Same in our jurisdiction.
And others, both agencies would have supervision. The pretrial agency, probation office, they would try as much as they can to coordinate so that if there's a drug testing condition or a reporting condition, if one officer or one office could do that particular condition instead of both of them happening multiple times, that's one way of making sure the supervision stays somewhat coordinated. But yeah, the pretrial agency would assume the pretrial case, probation would continue with the probation case.
And I'll just throw in just a little bit there. My background is in the state of Illinois and in various types of supervision in Illinois. And I think the most important thing is to have that collaboration and that conversation so it's very clear what's going to happen. And so it's very clear. I don't know that there's a best case scenario, whether it always should stay with pretrial or should always stay with probation. But again, kind of looking in your jurisdiction that the parties have gotten together and made that decision and everybody knows what's going to happen and how that's going to be monitored successfully. Okay, here's one. Should pretrial supervision continue when cases go into statuses such as deferred disposition or a taken under advisement status? And the question is asking because this could really impact the individual's length of supervision, which could be extended for 12 months or more in some cases.
So,
I'm sorry, go ahead.
No, go ahead.
Well, this just brings me back to an earlier question about the distinction between monitoring and supervision. And it also brings me back to making sure that there is something on the record so that when the decision is made, you are moving from pretrial status, you are entering a plea to get a deferred disposition. That's a hearing, and the defendant has right of notice and to be present and heard. And so a pretrial agency probably shouldn't just drift into that. It should be a specific hearing with all the rights attendant to that. And then I would look at, again, your data and that my earlier comment about monitoring versus supervision. If it's a deferred disposition, what are the terms that are required? What is necessary for pretrial services to do if pretrial indeed is assisting in the monitoring of that successful deferment?
My thinking is if a case is no longer being adjudicated, then there's no pretrial supervision that should continue. If my goal as an agency is making sure that you make a court date and remaining arrest-free while the case is pending, that goes away when the case goes away. Liz is right. We need to discuss whether or not the agency has some supervision responsibility with that new status. But generally, if I'm not being adjudicated, there really shouldn't be an issue of bail anymore.
Thank you. Okay. Some good questions. 3 more questions now. Has there been a conversation about adding a 4th M, being an M to address maximizing equity?
The answer is no, but that's an interesting question. I think the assumption has always been that in maximizing release and appearance and public safety, you're sort of bringing in an equity feature to it. But yeah, perhaps that's a discussion we need to have, whether promoting equity, even though that's not in most bail statutes as a purpose of bail, does that belong somewhere in what we're trying to do?
Yeah, and maybe just sort of talking not specifically just about in release, but in everything we do, right, should be done with an equity lens.
Is there a standard process for defense attorneys to obtain copies of the pretrial services recommendations? And I'm assuming maybe they're meaning the investigation report prior to the arraignment.
So I guess that would depend on, again, your jurisdiction. There is no standard process because, again, as we heard earlier, some jurisdictions, you know, give the assessment prior to initial appearance, some of them after. So I think that what your statute says on sharing the pretrial information, whether that's just with the court and the court has the option to give it to prosecution and defense. But yeah, that's really going to be up to your jurisdiction. There is really no standard process. You know, we share ours with defense and prosecution prior to arraignment electronically. They get sort of the score and the factors that went into that score. So
yeah, the standard, the 2020 and 2024 standards certainly recommend that bail reports be shared with defense and prosecution. It would be a little difficult to be a well-informed advocate for an individual if you know nothing about, you know, their risk or their background. Janice is right, though. It really is going to depend on, you know, how your system handles that or wants to handle that.
All right, and our final question before we wrap up is, has NAPSA had discussions about utilizing pretrial standards for youth, so juveniles detained pending disposition?
So are you talking about juveniles charged as adults? I'm assuming is what that question was referring to.
It wasn't clear. I read it the opposite, Janice, but it wasn't clear to me.
Yeah, because so like pretrial release for most people is going to be like that adult population. I don't know how many juvenile pretrial programs are there, because usually juvenile probation has their own sort of programs for those people prior to adjudication or any type of disposition in juvenile court, which is going to look different. Yeah, so if it's in terms of juveniles charged as an adult, then we would apply the same pretrial standards that we do to adults in that situation. But yeah, so I'm not sure how to read that.
All right, so we just have a couple of more minutes here to finish up. You've seen that we had up on the screen a feedback survey, so you can scan that QR code with your phone. Also, it'll be emailed to you as being a participant today, so we really hope that you could take the time to give us some feedback. We were so excited about the amount of participation we had today, and we'd really love to know what your thoughts are. We also are planning additional events and sessions sessions in the future. And so this can help inform those sessions. And so please take a moment to fill that out. I will say we do have our next session coming up. We are co-sponsoring that with TAPS, which is the Texas Pretrial Services Organization. That will be October 29th of this month at 3 p.m. Central Time. And the topic will be measuring what matters. So again, that is one of the fundamental courses that we would have had at the NAPSA conference, but had to cut short because of the hurricane. So then that one again, October 29th, 3 p.m. Central. You can look on our social media sites, have that, and I will also be linking it again very soon. So be on the lookout there and as well in your emails. And then there was a question earlier about sharing the slide deck, and I kind of fumbled over where I would put that. We will add that to the website. So if you go to the NAPSA website, if you search NAPSA Pretrial, because there are other organizations called NAPSA out there, NAPSA Pretrial, and then there is a specific page regarding the standards. Click on that and we will have that uploaded. It's not there yet, so give me just a little bit, but I will hope to have that there within 24 to 48 hours. So with that, that being said, I want to thank everyone for coming today. It's been a real pleasure and honor for me to be here with these wonderful, wonderful experts in our field, and just wanted to see if any of you had any other last comments.
Well, no, I just wanted to thank everybody who took the time to hear about the standards. The interest in the standards certainly is something that NAPSA is really proud of. It's nice to know that these are useful to the field, and we can continue to make this unique contribution to pretrial practitioners.
All right, with that being said, thank you. Have a wonderful day, everyone.
Thank you.